You are studying in Canada or working to build a permanent life here when the doors lock behind you. You are under arrest. Inside a holding cell, it is easy to lose your bearings. In that high-stress moment, a single thought usually takes over. You might assume this arrest is the end of your time in the country, that you will be deported as soon as you walk out of the station. That fear can make you desperate. To end the nightmare, people often feel pressured to plead guilty to whatever is in the police report, just to get out of custody and back to their lives as quickly as possible. Under Canadian law, an arrest is an allegation. It does not trigger a removal order or an immediate flight out of the country. At this stage in the process, you have not been found guilty of anything. Ironically, acting out of that initial terror is often what causes people to ruin their chances in Canada. A rushed guilty plea creates the very criminal record that leads to the consequences they were trying to avoid. An arrest by Canadian police is an unproven claim. It is not a final judgment on your legal standing or your right to stay in the country. Local police and federal immigration authorities operate under different laws and carry different burdens of proof. One investigation does not automatically complete the other. Even a transfer to a Canada Border Services Agency holding cell is a temporary administrative step. It is not a final removal order. Anyone detained for immigration reasons is entitled to a mandatory review within 48 hours. The system is built on a default of release while the facts are sorted out. Navigating the first 2 days requires a focus on the facts. The process is designed to weigh evidence before any permanent decisions are made about your status. Your level of risk depends on your status. Canadian citizens are immune to deportation. Their right to remain is secure regardless of an arrest or a conviction. For permanent residents, you only lose status for serious criminality, a conviction carrying a 10-year maximum or a sentence over 6 months. For foreign nationals, like students, the safety net disappears. Any hybrid or indictable conviction triggers inadmissibility. The turning point is the judge's verdict. The Immigration and Refugee Protection Act reacts to the court's decision, not the initial police report. While your status determines your risk, the legal conviction is the actual threat to your life in Canada. Once you are released, the focus shifts to the upcoming trial. This is where the battle for your status is won or lost. Criminal sentences often carry collateral immigration consequences. A sentence that seems light to a citizen could be the specific trigger that leads to a non-citizen's deportation. A defense strategy can include negotiating for a conditional discharge under Section 730 of the Criminal Code. A discharge is legally distinct from a conviction. By avoiding a formal guilty verdict on your record, a foreign national can remain in the country and avoid being labeled inadmissible. A coordinated criminal defense protects the life you have built. Panic leads to mistakes. Strategy leads to stability. Time is the most important factor. You have a window to build this strategy before you enter a plea in court. Contact Pax Law Corporation. Our team focuses on the intersection of criminal defense and immigration law to help you navigate this process. An arrest starts a long legal process. With expert intervention, an allegation can be fought, and your future in Canada can be preserved.